Thank you very much for inviting me here today. I am just a civilian at this point. Mr. Stacko was my former employee, I think, in the interest of fairness and candor. I appreciate Chairman Lento and members of this committee, and particularly Assemblywoman Markey, for extending me this invitation to be here today. This bill is probably one of the most important criminal justice bills that you may ever vote on in your entire legislative careers. I know this is a difficult statement to believe, but I believe it is to be a true statement. For this vote has the potential of telling the victimized, the vulnerable, the voiceless, the rejected, the passed over, and the trivialized, whether their elected representatives can and will stand up against some of the most powerful lobbying groups in the country, amongst which is the Catholic Conference of Bishops. There are others. There are perhaps many here today who will speak about rape and other violence between intimate partners, incest or other sexual assaults and crimes in families, human trafficking, sexual tourism, and all of the rest of the dreadful crimes committed against children and adolescents. I will, however, continue to confine my remarks to the anal sodomy, vaginal rape, masturbation, and fellatio committed by Roman Catholic priests in the Archdiocese of Philadelphia upon hundreds and hundreds of children and young adolescents under their care and supervision. It was not uncommon to find sexually abused children under the age of 10. However, many more were pre-adolescents or young adolescents. I would hasten to add, however, that this issue is far broader and could apply to many groups and individuals: Jehovah's Witnesses, Orthodox Jews, so-called religious cults, and those with no particular religious affiliation or association whatsoever. My grand jury reports were, I believe, the first in the country by a prosecutor who published names and photographs of priest offenders, which was picked up by other organizations and published nationally. And these are the photographs and the information about these priests. At least 63 priests were named as sex abusers, and an additional 104 were and still are being investigated as having been or still are identified as sexual predators. Some of those who were credibly accused of sex crimes were still in unsupervised contact with children. 2 cardinals, Cardinal Kroll and Cardinal Bevilacqua, several bishops, more than 6 monsignors, and many priests are also named, and how long they had known about sexual pervert priests in their midst. Many documents attesting to that knowledge, some of which I brought by way of the Philadelphia Inquirer, because I didn't want to haul around 30 pounds of documentation. But in this newspaper article, which is titled "An Immoral Cover-Up," contains within it copies of my grand jury report with documents, excuse me, Mike, with documents, some, but not all, that were in the grand jury report showing who knew what and when. Yes. Forgive me for doing that. Many documents attesting to that knowledge and clearly proving how these hierarchical people engineered the cover-up of these crimes with the cardinal or others of the church's hierarchy's signature on them were attached as part of the grand jury's public report. When asked about the existence of clergy sex abusers to the church, repeated in public lies, denials, dismissals, minimization of the nature and or extent of clergy sexual depravity were the order of the day. This was true whether these statements were offered to the press, the public, their faithful, or us. Church hierarchy and their attorneys tried repeatedly to get us from getting these files because they knew the true extent and nature of these crimes were all well documented with the signatures of those clergy involved in the criminal cover-up on each document. Each secret file demonstrated careful planning designed to thwart revelation of clergy criminality and their own depravity, and especially to keep victims at bay from going to law enforcement. The evidence adduced demonstrated that these men don't think that the concepts of truth, decency, or morality apply to them, and they certainly don't think that the laws passed by bodies such as yours apply to them either. These prelates had intricate knowledge of, complicity in, and deliberate concealment of huge numbers of serial acts of sexual predation upon children sometimes lasting for decades. To their everlasting disgrace, this posture was often adopted for the purpose of shielding the church from, quote, embarrassment or lawsuits. But when brought to the light of day, these documents revealed how deep-seated, pervasive, and pernicious sexual perversion committed by priests is. Protection and care of the innocent victims was often far from their minds. Protection of many good clergy was an afterthought. Losing their moral authority was missing. Losing the trust of the faithful, discounted. In other words, the scandal and even the secondary fallout were to these men worse than sodomy and rape. Better to keep the church free of scandal that they themselves were culpable of perpetuating as enablers, accomplices, and co-conspirators than to be exemplars of Christ's healing mercy. This is how your very abbreviated statute of limitations helped predators of every kind avoid and evade the law. When the heat from victims became too high, these princes of the church and their minions simply transferred these predators to different parishes and schools where an ever new and young supply of unexpected victims were served up to them. Sometimes they would buy the silence of victims and their families by providing psychiatric or psychological care if the family signed a confidentiality agreement or agreed to give up confidentiality of treatment providers, not so they could monitor the progress of the victim, but to turn them over to church lawyers if the victim went to law enforcement or obtained advice from an attorney. Other times, the church would threaten victims with excommunication or public denunciation. In some cases, the church would hold secret trials, again, not to vindicate the child victims, but to protect the predators by gathering information about the victim's psychiatric record, history of suicide attempts, and so forth, also to use against victims later on. The bulk of the evidence which my two grand juries exposed was the basis for the latest grand jury report in January 2011, since all of the testimony except for the new victims was adduced during my 4-year investigation. Criminal charges were lodged this time for sexual assault of a 10-year-old boy and a 14-year-old boy with the attendant cover-ups and so forth. 1 Monsignor, 3 priests, and 1 Catholic school teacher were arrested and are awaiting trial. Predictably, when victims finally can take no more and go to the public, either to law enforcement, the history of clergy sex abuse reads like a carefully constructed script. These church figures and their attorneys simply won't allow their church to be disgraced or involved in scandal. And they certainly don't countenance public acknowledgement of culpability except in carefully contorted, vague, and essentially meaningless non-apologies, usually set off by the word if. Instead, they plead the bar of the statute of limitations and fight like tigers to prevent a longer statute of limitations, such as this one, from being passed, and to prevent a 1-year civil window from being passed as well. Fortunately, the statute of limitations bill and a host of other child protective measures that resulted from our grand jury investigations did pass our legislature, and we are very, very pleased about that, and we hope the same thing happens here. The statute of limitations was raised from 12 years after a victim reaches 18 or age 30 to now age 50. Judged by this alone, your proposed change is a very modest one, and I mean no disrespect by that, so please don't take it as such. In addition to that, right now as I sit here, there is a bill pending in the Pennsylvania legislature to remove the statute of limitations for these kinds of crimes entirely. Contrary to the dire predictions that because of this expanded statute of limitations, there would be a veritable flood of old cases that would overwhelm the courts and confound the defendants, this just has not materialized for reasons which you have heard and will continue to hear today. This is understandable and perhaps may be instructive for this committee. If some witnesses here today brings up this tired canard, it'll overwhelm the courts. Most cases of child abuse, as you have already heard, and I will again iterate for you, of every kind, every kind, no matter who the perpetrators are never reported to law enforcement, no matter the identity of the perpetrator. So many victims have been so emotionally traumatized, broken and damaged, that even many years later they can't bring themselves to confront or recount their own horror in public. There are those who would try to derail this bill because of the false claim that this would deprive putative defendants of a defense because they couldn't account for their whereabouts on a particular day or on a particular location many years later, or the more traditional passage of time, fading of memories, and the usual stuff thrown at legislative bodies. This is just disingenuous at best and at its heart false. In the cases I am speaking of, or similar ones, whether committed by Catholic priests, individuals, family members, or other, these crimes are never have been, and will likely never be, single date specific incidents. Even the perpetrators won't know the exact date unless they kept their own predation notes. The precise date of each step in the sexual seduction started, they don't know unless they took a note, or what act was committed on which date. But they do know that they did it. They know it very well. Unlike robbery or a killing or any other crime where a certain date and time or a single act of stranger rape or other kinds of similar crimes, these kinds of crimes, the predation against children, are long-term projects. Every move is carefully choreographed, and each child specifically and carefully chosen through trial and error. Then they're painstakingly groomed over a significant period of time. The acts and activities from... Can you turn that off? That would be helpful. Sorry, somebody's phone went off in case the camera doesn't know why I turned around. The acts and activities from brushing against a child, reading certain books, talking about things personal, either sexual or not in nature, romping, wrestling, nude bathing, and the like, are well thought out so that only the weakest and the most vulnerable and obedient children will be caught in the eventual net of sexual perversion. Therefore, pervert clergy never have to think,
He can't do it.
gosh,
He knows how to work it.
what can I say?
He's not being rude.
A modern technology, can't turn it off. Therefore, pervert clergy never have to think too much about who and where and under what circumstances, or anybody else for that matter, they raped little children. They always knew. Times and dates are not criminal to these kinds of criminal prosecutions, specifically because they happen over such a long period of time. Indeed, even the victims can't pinpoint exact dates and times when the games of sexual conquest began, or exactly what happened when. Moreover, if ever reported, it's not for many months or, as you've heard in many cases, years. Children who are or may be plied with sexual favors such as unending attention, affection, trips, movies, clothes, shopping sprees, beer drinking, being shown the priest's own private collection of porno may, because of their innocence, think that they are, quote, special to the priest. Indeed, children often look at these men as fathers, loved ones, and heroes. In their innocence, they have to be carefully groomed into their victimhood. Almost never is a specific act's timing or date relevant or even necessary. Thus, the simple question to the perpetrator is, as a prosecutor, did you on multiple occasions seduce, rape, and or sodomize this child? Not the particular date each individual act occurred. That the acts occurred is paramount. There's one final thought that I would add, and that is, the shorter the statute of limitations, the greater the likelihood that all sexual abusers of children and adolescents will never be revealed. Thus, legislatures, such as those in this body, should feel secure that legislation which is appropriately lengthening the statute of limitations for crimes like this protects society as a whole, does not alter the rules of evidence or shift the burden of proof, as Mr. Miller said, is a most effective tool to vindicate victims and protect society, and prevent sex perverts from the comfort